please. Running a little behind, we'll catch up. Okay. I'm going to call the meeting to order of the Enforcement Committee of the Medical Board of California. Good afternoon. I want to welcome you to the Enforcement Committee of the Medical Board of California. I'm Dr. Ron Lewis. I'm the chair of this committee. And as usual, I want to ask all of you to turn off your cell phones. And for board members, they're going to be either keeping them off or off the table. You may notice the board members accessing their laptops during the meeting. They're using their laptops solely for the purpose of accessing board meeting materials that are in electronic format. This is an official business of the Medical Board of California, and as such, disruptions of the board's business will not be tolerated. We have a designated time on the agenda for public comment, and we'll be asking for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business, and should anyone feel the need to disrupt the meeting, I'll ask the person to conduct himself or herself in such a manner that permits the board to transact its business. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on the agenda item and you wish to speak on that particular item, please raise your hand and I will recognize you. I would like to remind all speakers to complete a presenter slip so that I may call you by name at the appropriate time, and the record of this meeting can be full and complete. You will, if you could please give your speaker slip to Ms. Romero, and Ms. Romero is identifying herself in the first row there for everybody. This meeting will be available by teleconference, and individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconference process. For those members of the public participating by teleconference, please wait until the moderator has introduced you before making your comments. To request to make a comment during the public comment period, press your *1 on your telephone, and you will hear a tone indicating that you are in the queue for comment. If you change your mind, you do not wish to make a comment, press the # sign, and that will remove you from the queue. Please remember to mute the volume on your screen because it does cause a lot of feedback. Assistance is available throughout the teleconference meeting, and to request assistance, press the *0 key. Each person will be limited to 3 minutes per agenda item. However, during agenda item number 2, which is public comments not on the agenda, the board has limited the public comment period for individuals on the teleconference and those present here to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. And then after 10 minutes, no further comments will be accepted. Armando Melendez will be assisting me in receiving public comments via teleconference during this meeting. And you are over there, so I see you over there. I will do my best to call upon everyone who has supplied a slip for the agenda item and recognize those who wish to make a last-minute comment also. So if you have a last-minute comment, if you could fill out a speaker slip and give it to Ms. Romero, then we can keep a record of your name and for the official record. I will remind all speakers to please stay on topic and keep your comments to 3 minutes or less. We plan to end today at a reasonable hour. I'm not sure what within the next hour. We may take some items out of order to accommodate this schedule. I would like to call the meeting to order and ask that Ms. Romero please take roll.
Dr. Kraus?
Present.
Mr. Louie? Ms. Shipsky? Mr. Serrano-Swool? Ms. Yaroslavsky?
Present.
Dr. Yip?
Present.
Dr. Lewis?
Present.
We have a quorum.
Thank you, Ms. Romero. We have a quorum. Now, the section 2 is, or agenda item 2 is public comment on items not on the agenda. And do we have any slips from anybody who wishes to comment? We don't. Do we have anybody who wishes to comment on the telephone?
At this point, no.
Okay. Very good. So we move on to agenda item number 3, which is the approval of minutes from the October 23rd, 2014 meeting. Are there any additions or corrections to the minutes from the members of the panel? I don't see any. May I have a motion to approve these minutes as submitted? Mr. Osofsky moving. Do I have a second? Do I have a
Second.
Do I have a second or a third? Okay, very good. So have a second. Dr. Kraus.
Okay.
Just put him, whatever. That'd be fine. Okay, I'll look at that. Are there any comments from the audience? Is a comment from the audience on there? That's number 5. Keep that. Any comments on the telephone?
You have no one in queue from the phone.
We have a comment from the phone?
None.
None. Okay. Now, we have a motion, seconded. All in favor? Aye. All opposed?
We're gonna do a roll
Oh,
call vote.
that's right. We officially have to do a roll call of each vote. So, anyway, all in favor, and then we'll state your name. All in favor?
Howard Kraus.
1.
Dr. Lewis?
Yes. Approve.
Dr. Kraus?
Yes.
Ms. Yaroslavsky?
Yes.
And Dr. Yip?
It's a little awkward. It's new for us, so try to get used to it. Okay, any opposed? Any abstain? No. Okay, minutes are approved. We're now moving to agenda item number 4, which is the update on the investigative process at the Department of Consumer Affairs. We have Mr. Gomez, Ms. Castro, and Ms. Kutschmeyer. Could you please welcome you to the presenters table?
Good afternoon, Chairman Lewis and members of the Enforcement Committee of the Medical Board of California. Again, my name is Michael Gomez. I'm Deputy Director for the Department of Consumer Affairs Division of Investigation. You want to make an introduction?
Yes, my name is Laura Sweet, Deputy Chief for the Health Quality Investigations Unit.
And it's always an honor to be in front of you. I'm Gloria Castro, your Senior Assistant over the Health Quality Enforcement Section.
Laura, would you like me to begin, or do you want to begin? Want to begin?
Sure. You've asked us to appear here jointly today to get an update on the status of your investigations over at HQIU and how we're working together with everyone on a team-based concept. I'm happy to report that we continue to work on the joint manual. At this point, I'd like to commend the participation of Ms. Anita Scurry, retired annuitant, former legal counsel, who has attended every meeting and allowed her expertise and knowledge and demeanor to have a lot of effect on the nature of the meetings and what we're trying to hammer out as a team. And what I wanted to say about that is that we've been executing these duties for you the past 9 years, and at your direction, we're trying to enter into a joint agreement with HQIU to have common interests and goals outlined in a protocol that will appear to be much more streamlined than what you've seen before. Nonetheless, after that whole draft is concluded, we will still be sending it up to the Attorney General with my recommendation to her as to whether she should adopt it as the protocol that will apply to her staff. So I just wanted to make sure everyone was aware of that, that even after we agree with DCA, we still have to send it up my chain of command, okay? The main purpose in all of our manuals has been to set forth the procedures by which the investigations will be directed by assigned DAGs, Deputy Attorney Generals. And with that, this entails also the legal review and provision of legal advice and investigations. And specifically, the manual will cover other important aspects of efficiencies that have been offered by DCA, some of which already were in our July 2014 VE manual. So that way we can continue to work your cases. But I think what Mr. Gomez and I want to make sure that you know is that with or without a joint manual, we continue to reinforce all of your goals and policies and public protection, public protective directives, basically. The attorneys are thoroughly involved in all of your investigations. Mr. Gomez and his staff continue to treat them a little different than the other investigations that are also housed in the Division of Investigation. And for example, as one aspect of how our teams are working together really well, in the last 6 months we've had 20 Penal Code Section 23 bail recommendation orders, and that's actually quite a bit for a 6-month period, and that's one aspect of a successful team collaboration. You want, what? Yeah.
And yes, members, our presentation with Laura Sweet today will also cover statistics and data in terms of our enforcement, but I want to speak to you a little bit about the enforcement manual itself. This draft that we have is basically 95% complete. We only have one outstanding issue to address, and the progress that the Department of Consumer Affairs and the Attorney General's Office have made regarding the creation of a new VE manual has been a lot of work, and my thanks, I guess, to Gloria in particular. You've been a pretty good advisor in terms of where we go with some of this stuff and the things we thought about and the things we didn't think about. The protocol was written by a team, as I may have reminded the board, of the Executive Office, the Attorney General's Office, and our legal counsel, Anita Scurry, the Deputy Chief, Laura Sweet, myself, and we have done a lot of work on this. And the product that we have, that is, we're almost there, has been the work of a lot of consensus building, and to a large extent, almost an argument in terms of good, healthy argument in terms of where we're going in terms of the policy of our respective roles. To date, the draft represents a collaborative effort, and we have done a lot of work to get to this point. Our next meeting is scheduled for February 4th, and hopefully the one outstanding issue, which is the participation of the Deputy Attorney Generals in the investigative interview setting, is the outstanding component that we need to come to agreement to, but I feel confident that we'll have some resolution to that. I wanted to briefly explain the most important differences between this protocol and the current 3rd edition of the Vertical Enforcement Manual. At the onset, the Department of Consumer Affairs believes the previous versions of the manual have served their purpose, and the MBC, the Medical Board of California, and the Attorney General's Office implemented the vertical enforcement and prosecution process and manual that we live by today. So the model that we look at in this protocol is we took the knowledge and lessons gained from working under the prior versions and incorporated them into this new protocol. Our primary goal was to create a product that reduced delays in the enforcement process and increased accountability, thereby enhancing consumer protection in California. Our secondary goal was to create a product that eliminated the confusion caused by the significant redundancies in the 3rd edition, created confusion caused by, greater clarity in the organization and product chronologically, and would also make it more user-friendly, and most importantly, used a neutral tone in using the manual itself, so the two agencies really had a foundation for true teamwork. We believe the product allows the user to find all the information in one topic, on one topic, in one place. Unlike the current manual, it also recognizes that both the investigators and the Deputy's Attorney General are trained professionals with separate areas of expertise that need to be recognized and respected by each other. In addition, we're working with the Attorney General's Office on the VE manual. DCA has been communicating with Ms. Castro on a regular basis to address current process issues to ensure that enforcement cases continue progressing in the most efficient and effective manner possible in the absence of a joint manual. So going back to what you said, Gloria, that we're still there. We have a manual. We just think there's more efficiencies that could be achieved. What is exciting about a lot of our interaction right now is that we are currently in discussion with the Attorney General's Office in the creation of a cloud, an IT cloud, allowing documents and evidence in our joint casework to be conveniently available to the vertical enforcement team. And Laura Sweet is working with the Attorney General's Office to assist in the cloud development. This is exciting technology that will give us immediate access to the documents that are needed on our cases jointly as we review, assess what the valuable evidence is or isn't, and what we need. And with that, I can say that thanks for opening the door for us, Gloria, that we were able to go down and go down that road of a good IT project. Okay, I'll thank the Attorney General on behalf. And then what I'd like to do before, if you'd like to ask some questions before we begin on the statistical data presentation, we can do that if you'd like. Okay.
I'm more than willing to wait.
Yeah, I think we'll just go ahead and wait. I think, Laura, you can do your presentation, and we'll have questions at the end.
Okay. With that, then, what we'll do is we'll begin on the presentation from the HQIU side regarding where we are with staffing, where we are with our caseload, our case aging, and with that, I'm going to address the staffing and personnel changes we've had in HQIU, and then Deputy Chief Sweet will address enforcement statistics, et cetera. Since our last report, several individuals retired, notably Chief Renee Threadgill, LA Area Commander John Harai, who's in Northern Area Commander Terry Bennett, and Supervising Investigator Marianne Eckhoff. Fortunately, John and Marianne were able to stay with us as retired annuitants and train their successors or their new people to start supervising and managing the caseloads in the direction of the division in terms of the vertical enforcement model. We have already interviewed and announced the promotion of John's replacement for the metro area, and that would be Robert Polito, who joined the Division of Investigations HQIU via the Medical Board of California on October 31st of 2012. Bob brings a tremendous amount of leadership experience to us. He worked over 20 years as a detective, and over 15 of which were as a detective supervisor with the Los Angeles Police Department. Bob is a graduate of the California State University of Los Angeles, the Sherman Block Leadership Institute, the West Point Leadership Program, and the USC Leadership and Organization Management Program. Since coming to HQIU, Bob has transitioned successfully into the role of a specialized investigator for the Medical Board and for the work that we do under the Medical Practice Act, and recently volunteered as a field training officer. Ms. Eckhoff, who was the supervising investigator in the Cerritos office, will be replaced by a current supervisor, Jeff Gomez, out of the Glendale field office. And so we're now recruiting, actually we're not recruiting, we've already interviewed for the Glendale field office. We're awaiting that announcement for a couple more weeks until we know where everybody's going to fall, if you will. As of this report, we have 17 sworn vacancies. As previously mentioned, several people retired, which has resulted in promotions, and we have candidates in background to fill at least 6 of those 17 vacancies. But again, we were having to compete with agencies who offer different pay scales than we offer, and different benefits than we offer in terms of the kinds of work and the amount of work that they do. We are having difficulty recruiting medical consultants in several of our southern area offices. Commander Kathleen Nichols is going to be sending out letters to experts in the San Bernardino, Rancho Cucamonga, and San Diego areas to hopefully encourage interested individuals to apply for this important work. We have been placing articles in the newsletters that has not yielded too much results, so we're going to try different tactics in terms of our recruitment efforts for those positions. In terms of processing cases, There has not been a significant change in case handling at this stage. Cases that are being proposed for closure or transmittal are sent electronically to Ms. Kirkmeyer in order for her to approve of the case disposition. Tremendous energy, again, has gone into, or has been expended into the streamline the vertical enforcement process, which will be discussed in further detail at the full board meeting. We believe this will also be instrumental in improving morale and moving cases forward. We have also tried to offset some of the financial disincentives for investigators here by offering alternative work weeks, the 410 plan, and providing more training for them, more training opportunities in terms of not just skill development, investigative development, but leadership development and management. That said, I'm going to turn it over to Deputy Chief Laura Sweet.
I think I'm okay. Okay, no. On to the statistical information. We've prepared some charts for you to look at. I hope you can see them better than I can see them. We do continue to have a few challenges extracting completely accurate data from Breeze, but we're seeing significant improvement. Breeze has not yet learned how to calculate the dead time between when a case is closed. For example, if we're awaiting a criminal disposition, and so we will close the case because there's nothing we can do on it, and then we will reopen it once we have a conviction to move forward. Breeze continues to add all those days into the case, whereas with the CAS system, that time was actually able to be extracted. So the Breeze team is aware of this, and the programming folks do anticipate that this will be resolved by April of this year. There's also a problem calculating cases that have been reassigned. So keeping that in mind, a lot of this data on this very first slide has required manual intervention. Dave Russwinkle, who's the analyst for the Medical Board's Executive Office, has worked tirelessly in providing as accurate of data as is possible under the circumstances. So that said, the first chart is based on information Mr. Russwinkle provided to us for physicians and surgeons. This is extracted from both CAS and Breeze, but you can see the time that it takes for once a case is assigned to an investigator to the time it is closed or resolved. In fiscal year 10-11, and this came out of CAS, it took us an average of 312 days. The following fiscal year 11-12, the number was 264. The fiscal year 12-13, the average number was 268 days. The first fiscal year where we extracted data from Breeze, the case average age was 245. And the first 2 quarters of this fiscal year, the current case age average for closure is 258 days. Sorry, this is not the way I wanted it to be. Okay. The next chart compares snapshots of productivity between the first half of fiscal year 13-14 prior to transition to the first half of fiscal year 14-15 post-transition. And this data is derived from our monthly case activity reports and also includes all cases we investigate. So this is not just physicians and surgeons. This includes allied health professionals. As you can see, the number of cases assigned has dropped by 206, which is significant and attributable to the implementation of the non-sworn complaint unit taking on 801 cases and conviction of crime cases. This has been helpful to the field in reducing average caseloads, but I do think it bears mentioning that these were, if you will, uncomplicated cases that enabled investigators to improve the average time to close a case, because these cases typically could turn around in 60 to 180 days. So an unintended consequence could be that the average time it takes to close a case in the field office could potentially rise because the cases the investigators are working are only the most difficult and complicated cases. There have been 62 fewer cases closed and 14 fewer cases referred for citation and fine, and 50 fewer cases referred to the Office of the Attorney General, and 15 more cases referred for criminal action. And I think there are many causes for this. There's been much uncertainty with the impending transition. There has been uncertainty with impending retirements. Vertical enforcement has presented its own unique challenges. And in addition to SB 304, staff have also had to adapt to a very different computer system during this time period. And so we have not been able to give staff the usual information we used to be able to track progress. But again, we're hopeful that those will be resolved shortly. I think I'm missing something here. Okay. Several years ago, one thing I also want to stress about all of this data, especially the data that's manually extracted, is that it has not been vetted and it has not been verified. So this is information we've been maintaining in our district offices to try to track how well we're doing pending some of the corrections in Breeze. So several years ago, we began paying close attention to age cases and instituted the Age Case Council to troubleshoot cases that seemed to be languishing. And our first demarcation line was cases over 700 days old. And throughout the years, because of the elimination of these old cases, we were able to keep bringing down the threshold for scrutiny. And most recently, the magic number of increased detention is now 550 days. So this chart here, again, includes all cases, physicians and surgeons, as well as our allied health cases. And so if you compare January 2014 to June, no, this is not the right
When you say, excuse me, when you say allied health care, is that medical board allied health, or is that allied health throughout the system?
It's podiatry board, so these are the cases that medical board has serviced in the past. Podiatry,
So I just make sure that
osteopath.
it's under our purview.
Correct, correct. Yeah. Oh, sorry. Oh, okay. So anyway, if you look at cases that are 550 days old, we've actually improved. We've lowered the cases from January 2014. If you look back for an entire year, we've reduced cases over 550 days old by 2. And cases over 1 year old has seen a little bit of an increase, but not overly significant. And these are just additional comparisons between January to June to January 2015 for cases over 550 days old. This is by district office, so that the different offices can see how well they are faring. Now, I want to be careful in explaining that there is a lot of unspoken information within these individual office charts, because I don't want any office to feel particularly badly. One of the offices depicted here had that has a high number of old cases endured a significant period of time without a supervisor. And once we did hire a supervisor, train the supervisor, this was a person who had been placed on SROA from another agency, a surplus list. And once he was offered his old job back, or a job that paid a little bit more money, he left us. So that kind of disruption does impact the functioning of a district office. And I think Chief Threadgill articulated this when we hired numerous individuals who were laying off staff, and we spent a lot of resources hiring them, training them, and a vast majority returned to their former employment due to compensation disparities and other frustrations. And so that frustration plays itself out in these charts for several of the offices. In the offices where we have seen stable supervision and staffing, the case aging is generally lower. So, of course, that's not to say there is not opportunity for improvement, and we continue to look for ways to streamline processes and make the job easier. But the transition has been a great opportunity to review policies and procedures, and we are in the midst of that project right now and hope it to yield some suggestions for operational efficiencies we had not yet considered. All I can state with absolute conviction is that the investigators have been working incredibly hard with nonstop challenges, and I could not be more grateful to them for their resilience and devotion to protecting the public no matter what is placed in front of them. Lastly, as it relates to case aging, I wanted to tell you that in a renewed effort to focus attention on the case aging issue, staff were challenged to reduce cases over 365 days by 20% between November 1st and December 31st of 2014 with a contest where successful offices are receiving a pizza lunch hosted by Mr. Gomez and myself. 6 offices were successful, and the contest was reinstituted to encourage staff to reduce cases over 365 days by 25% by April 1st, 2015. And now that we are stabilizing, we are hoping we will be buying a lot of pizza. We've had some significant successes in the criminal arena during this quarter. A former physician who surrendered his license was recently convicted for involuntary manslaughter and is awaiting sentencing. This case was handled by Supervising Investigator Julie Escott from our Valencia office. The former doctor used a combination of lidocaine, fentanyl, and oxycodone and other drugs in a liposuction procedure that lasted more than 14 hours. And the cause of death was multiple drug toxicity. The procedure was performed in an unaccredited surgery center. He had no licensed assistants and had no life-saving equipment in the office, and sentencing is pending. In a case managed out of our Glendale field office by Investigator Ken Buscarino, a physician was sentenced to prison last Thursday for prescribing narcotics without a legitimate medical need. He was ordered to spend 2 years in jail after originally being sentenced to a total of 7 years in prison. The efforts of Investigator Brian Ansay in the Fresno field office, who worked as part of a multi-agency task force, led to a physician pleading guilty to federal charges for causing the distribution and dispensing of oxycodone. He was sentenced to almost 5 years in federal prison. And the last example I'll give you, although there are more, the efforts of Larry Bennett and our San Dimas office led to a physician being convicted of distribution of hydrocodone, alprazolam, carisoprodol, promethazine, and money laundering. And he was sentenced to over 5 years in federal prison. So there have been quite a few successes, particularly on the front to fight prescription drug abuse, that I wanted to share with you. We're very proud of these, the fulfillment of our mission for public protection and tackling these difficult cases. We remain within our budget and remain on course to do so. However, due to several retirements and some significant payouts, it is a little tighter than we anticipated. Although we don't believe this will prove to be problematic, it does mean we are paying close attention to it and utilizing asset forfeiture monies for training for health quality investigation unit staff. I'd like to conclude my portion of this report by commending our investigative staff for their ability to keep the work moving despite an unprecedented amount of change and personnel movement. And I'm optimistic that with the transition further away from us, the stabilization of staffing, that life will settle down and we will continue to see improvement with case aging and furtherance of our mission. And that concludes my report.
Thank you, everybody. Very good. And I think I can maybe speak for the rest of it. It's quite an improvement in the reporting and the progress from several meetings ago when we first started out and the transition occurred. So I applaud you on your continued success and improvement of the process. I'd like to ask if there's any questions from. Oh, you have more?
Yes, I do.
Oh, great. I'm sorry.
No problem.
Keep going. I was
Yes,
commenting.
what I want to cover is just a couple of thumbnail points on operational issues, training, the aspect of criminal cases and conviction case monitoring, and my cars, and then finally the cloud. I'll make my remarks very brief. The July 2014 VE manual that we have been operating under at the Attorney General's office will probably, if we can find a way to have this joint manual put into place, that July 2014 VE manual ends up becoming more akin to an operational manual that directs our staff and implements what the Attorney General sees as the directing authority over this program and the provision of legal advice. And so we'll be working on that and refining those things, because there was a lot of level of detail, which I think is important on such important public protection cases. With respect to operational issues, we continue, like has been already mentioned, we continue to operate in a transitional period where HQAU actively is interfacing with the AG's office on a daily basis. And currently the number of investigations that we have on our plate are about 1,100. In the past 6 months, we continue to inform HQIU of the best way to present cases to the Attorney General's office, such that transmittal guidelines and other operational communications are robust between me and Mr. Gomez and Ms. Sweet. The aim of this obviously is so that cases can be efficiently processed and tracked between offices, that the matter of scheduling of physician interviews, expert selection, expert report review, and our consideration for acceptance for prosecution goes as efficiently as possible to protect the public. We will continue to work on the transfer of knowledge, techniques, and history between agencies, and obviously it's always with the joint goal of protection of the public through high quality and efficient joint investigations. Now, with respect to training, Mr. Gomez and I continue to discuss ideas for joint training between our mutual staffs to improve the quality of your investigations. There is new staff obviously joining HQIU, and in HQE we've had some important retirements and new staff joining our office. So this will always be a continuing goal, and I note that Mr. Gomez and I take very seriously that the VE statutes actually require joint training, so we will continue to talk about those ideas. And as HQIU becomes acquainted with the business process and workflow with its investigators and how HQE manages work, we've also been reactive to the new ideas that they've brought to the table, and then making our process either mirror it or complement it where possible. And like I said before, in the meantime, our AG staff continues to follow the July 2014 manual, and which already implemented some efficiencies that we hope will make it into the joint manual protocol. Now, on the aspect of criminal cases, that is one major change I think that HQE will be instituting to react to the increase in number of criminal referrals by HQIU. Criminal referrals meaning any case that comes in that they have until now unilaterally thought is a criminal case, they're sending them over for consideration for the district attorney's office. Traditionally, we would work with Operation RX, one of the shops that the medical board used to manage that did criminal cases pretty much. And previously we were tangentially involved in unlicensed practices, the corporate practice of medicine aspect, which is criminal in its own right. However, because this practice is substantially different, HQE has had to change its view of criminal cases such that we will be managing parallel civil investigations, and while maintaining the integrity of the civil aspects of the case without really getting involved in the criminal aspect of the proceeding. There will be a DA assigned to whatever is referred, and at the same time, for your benefit as our client, we will track the statutes of limitation, we will track how long something sits at the district attorney's office, such that if anything is languishing, we can offer Mr. Gomez's staff some assistance in reaching out to the DA. And if it's decided that we will go ahead and enforce the rights that you have to discipline the license, notwithstanding a criminal investigation being undertaken, we will secure your rights by filing accusations or doing ISOs or doing whatever it takes. We don't want to not be involved in the cases, and we will get involved as much as possible within our parallel proceedings protocol that the Attorney General has. Another aspect of this is with the help of Ms. Kirchmeier, we are going to start tracking criminal cases a lot more closer after our conclusion of Penal Code Section 23 bail restrictions, specifically on statutes of limitation. We want to be helpful in that regard, and we will monitor those cases through our lead prosecutors. And like I said, HQIU has increased the identification of disciplinary matters as criminal cases, and they have been referring cases to the district attorney's office. Now, with respect to monthly investigator caseload activity reports, so-called MICARs, Mr. Gomez and his staff send me all of the MICARs from statewide. What we do with those is we have lead prosecutors look at the reports and report back to Mr. Gomez's staff as to dates that match, resolutions that match, and where they don't match, we just communicate that back to Mr. Gomez's staff. I know that there have been issues with Breeze and its ability to extract reports, and I'm going to just continue to work with Mr. Gomez on that sort of process at the 6-month marker to share what cases don't match, so that way, if Breeze needs to be corrected, then it can be done, so that these stats are actually validated.
Ms. Castro, can we,
Yes,
probably in the interest of time, maybe conclude?
yes,
Because I know Ms. Kirschmeyer wants to make a few comments also. If you want.
absolutely.
Great, thank you.
And I just want to let the members know, since July, I've been reviewing the closed cases from the investigative work. As you know, that with the removal of the chief of enforcement, Ms. Threadgill's prior position, and actually with the removal of Ms. Sweet, who would have been the one reviewing those cases, I've been reviewing those. I can definitely see the hard work of both the investigative staff with the Attorney General's office. However, there are cases, and I just want to let you know that there are cases when they come to my attention and I'm reviewing them, that I am going back to either now Ms. Sweet, prior to that Ms. Threadgill, and Ms. Castro on those cases and are asking follow-up. That's kind of new for the executive side of the board, and once we get our chief of enforcement that will be coming into the medical board, that individual will be doing that. The other thing I wanted to let you know is, as far as the budget, I know that was a concern for the members previously with the transition, that we do watch that very closely with our new deputy director who's been hired. She's going to be looking at that with staff and making sure that the appropriate charges are going to the medical board and the appropriate charges are going to the health quality investigative unit. And just really monitoring that. And then the last thing, I just wanted to add a comment to say that on the statistics, our staff continues to work with the department and also just within our own IT unit to get the statistics. I was hoping to have some better statistics to be able to give to Ms. Sweet and Mr. Gomez to present today, but unfortunately it just is taking us a while to get through those reports with the Breeze system and being able to identify the reports. So again, they're at the mercy kind of the medical board working with DCA, OIS, Office of Information Systems to be getting those reports together. So those are just the things I wanted to add.
Okay, thank you. Thank you, Mr. Gomez, Ms. Sweet, Ms. Castro, Ms. Kirschmeyer. I will open this up for questions from members of the board. Ms. Yaroslavsky.
How novel. So let me ask the question about, a couple of questions I have. How these vacancies that we hear about and we've heard about for years about other entities being able to hire your people, pay them more, give them better benefits, we've heard the story, been there, done that. But how is it affecting the caseload and the case closures and the case process? Is it putting you, forcing you into a situation where more supervisors are having to,
What happens is the biggest disadvantage to that is cases get reassigned. So there's a loss of continuity in the case. I think that's the number one problem. So somebody gets a case and then it's assigned and reassigned and reassigned. So it's, it's hard to take on something that somebody else has begun. And then that also increases the case aging. And it can increase the caseloads. Right now, the caseloads are manageable despite the vacancies. So I think, especially in Southern California and Northern California, we are having higher caseloads. And we have a pretty, well, actually, no, we've got a couple of vacancies in our Bay Area offices, which it is because we don't have as much geography where we can move cases to other offices up there. So they are suffering. Their caseloads are a little bit too high.
when you were speaking about the statistics before, you spoke about cases are closed and then cases are reopened and the statistics are there. Is that in fact changing what the bottom line number is? I mean, is it manipulating data?
No, because what happens is there's all types of scenarios. Well, you may have a scenario where we have closed a case because we have insufficient evidence to proceed. Let's say we have a case where we have a simple departure from the standard of care. We can't act on that, but we put the case aside, it's maintained for a period of time, and let's say we get another complaint with a simple departure from the standard of care. And then we combine those two cases together and have repeated negligent acts. So that it's not manipulating the data at all. Conviction of crime cases, we've talked about this at previous meetings where we might be working with another agency. They have filed charges. They forbid us to move forward because it could conceivably prevent the successful prosecution of their case. So we stand down, and it's not fair but charges are pending, so it's not fair for our staff to have this age and age and age, because really there's nothing that can be done. So pending or another example is a federal conviction. So a physician may be convicted in the federal arena, and it may take a year for sentencing to happen. And so in that scenario, there's absolutely nothing we can do. If we have enough to go forward with a suspension order, the Attorney General's office will assist us in that regard, but in some situations there isn't. So those are the examples of where that might happen.
But we've spoken before about the possibility of taking those numbers as a congruent number out of the statistics as a whole, so that we have more of a real understanding of what cases are taking,
Right.
how long they're taking, are they taking too long, are they meeting the balance of the expectation of the public within fair and reasonable time,
Right.
or not, and not letting those other cases that are long aging for whatever reasons be part of that number.
Right, and so what I probably didn't convey adequately is we are closing them, and so they're not acquiring time, but Breeze has not yet learned how to extract that time. So we are doing that. With the CAS system, we could not have that time tacked onto the case, but with the Breeze system, the Breeze does not know how to recognize that closure and reopen code, so it computes all that time. For example, it might be another year, so it computes that time as part of our case age average. So that's why I wanted to offer the caveat that Dave Russwinkle did go through all those cases that he thought were the outliers to manually look at them and recalculate them. So that's I just wanted to make you aware that it wasn't 100% perfect.
So when can we expect that Breeze is going to be able to work to get us statistics that are
April. We've
April
been
this
advised
coming
that
year?
it will be
April this year?
Yes, Member Yaroslavsky, we have on this closed open reassignment issue, it has been one of the focal points in this last rendition of fixes that we are focused on because of exactly for the reasons that you're speaking of. And our personnel have told us April of this year that it would be corrected, and we'll be able to really count the right data points for the right reasons for the right cases, et cetera. And that's what we're looking for, April.
Then the last question, I just have one more question, and that's on the cases that are taken under the auspices of another law enforcement entity by which you cannot move forward with those cases. As we've had the combined AG's office and the DCA office working together on cases, would we assume that on a go-forward basis that there might be an opportunity to have joint efforts so that it's simultaneously, we don't lose time?
Right. No matter if a case is tagged as criminal and it's under consideration from a district attorney's office, HQIU and also the Attorney General can't make them work any faster. I think Mr. Gomez and I are committed to try to have Sentinel events where we won't let it languish too long out there. We want to operate in a collaborative capacity with our law enforcement partners, and where possible, if there's a carve-out that doesn't jeopardize a criminal case, we're going to be parallel investigating that aspect of the
Right.
case. If the case is purely a criminal case and there's nothing else that we could do, that is an ISO case, okay, sometimes, and we want to put the public on notice too. So there's a balancing that has to take place. Ms. Kirchmeier becomes involved, and we can always put forth a placeholder accusation, one that doesn't jeopardize the criminal case, but that puts the public on notice that there's something going on here. The jeopardy with that, obviously, is that we don't want to go first, ever, because our standard, even though it's very high, it's clear and convincing to a reasonable certainty, it's a shade below beyond a reasonable doubt. If the doctor decides to try his administrative case first, that is the quickest way to, and we lose, or we get something very light discipline, even though the case is not the same, it will have an effect on the criminal case. And to the extent any of those issues are shared, which hopefully they're not, but to the extent that can be argued that they are, that's res judicata, and poof goes the criminal case. However, with that being said, these are outlier cases. They are far and few between. Sometimes people have criminal charges pending against them and they take off to Switzerland. I mean, we actually had someone that did that. And so for 3 years is just sitting there. So those are outlier cases that we can't do much about. But what we can do is just make sure that we can collaborate and put the public on notice and put,
Okay, good.
put forward your disciplinary rights to go after the license.
Thank you.
Okay, thank you. I will also take other questions, members of the board. Also remind members of the board that we do have, they're up for another round tomorrow, that we can ask further questions if we need to. So if you can hold it till tomorrow, that would be great. If
I'll
you
try and
want to
forget
ask
what I said today.
questions now. Any other board members have comments or questions? Okay. Mr. Gomez, it does concern me about the medical consultants, that you're having a hard time, and I think there are other avenues of outreach which you're going to explore. Not sure if newspaper is really thing. I think you have to press the flesh and try to convince people to.
No, Dr. Lewis, it's interesting you'd say that. That is one of the, not tactics, but one of the outreach we're doing is do it a little bit differently and
Yes.
use our medical consultants. Their venues or associations with individuals that we know we can recruit differently. And that's what we need to do.
Okay, thank you. Thank you, everybody.
Public comment.
Yes. Any public comment? Any comment from anybody on the teleconference phone?
Okay, if you do have a comment, press star and one, I'll open your line.
We have a comment on the phone?
We do not have any comments now.
Okay, good, no comments on the phone. So we're going to quickly move on to agenda item number 5, which is the update on the marijuana task force. After discussion at the last meeting regarding changes to the board's marijuana statement, several members had concerns about removing the requirement for an in-person examination. Therefore, at the full board meeting, it was determined that a task force would be established of 2 members to discuss this issue. Mr. Serrano-Sewell identified the chair of the enforcement committee, myself, and the licensing committee, which is Dr. Bishop, to this task force. On December 12, 2014, we met with the board staff in Sacramento to discuss this very important issue. At this meeting, we reviewed the board's current laws, the current marijuana statement, and the presidential decision the board had adopted on this issue. In addition, we reviewed new legislation that had been introduced on December 1st, 2014, also on this issue. The task force fully reviewed the laws pertaining to an appropriate examination and also reviewed the telehealth laws. Based upon our discussion and review, we came up with some recommendations that we would like the committee to review and approve today so they can move on to the full board meeting tomorrow. On pages ENF 5.1 and 5-2, you will see the discussion from the meeting and also our recommendations. The first recommendation is to amend the board's marijuana statement to address the telehealth issue. Based upon our review, the law authorizes the initial examination to be performed via telehealth. However, the standard of care must be followed, as do the requirements in the Business and Professions Code section 2290.5, which is the telehealth law. In this section of the marijuana statement on important points to consider when recommending marijuana for medical purposes, the task force recommends the following additional statement. Telehealth, in compliance with the Business and Professions Code section 2290.5, is a tool in the practice of medicine and does not change the standard of care. We thought it was important to point this out and draw attention to it. So if a physician expert were to review a physician's care and treatment when recommending marijuana for medical purposes, it must meet the standard of care, whether telehealth is used or not. So may I have a motion to recommend to the full board approval of this additional statement?
So moved.
have a
In a second.
and a second. Dr. Yips, a second. Are there any questions or comments from the members of the board? I don't see any. I have, this must be one public comment. This is from Stephen Ellis. I get that right? Stephen Ellis, could you approach the speakers table, please? Right up here. Yes. Thank you. I'm going to keep that.
Thank you, guys. I'm a cannabis physician from San Francisco. Been doing it for about 15 years. We've got greater than 10,000 patients, all of whom have underlying care for their problem at hand, a physician, chiropractor for spine issues, so forth. They all are documented up the yin-yang, statement from the doctor, MRI report, QME report, so forth. Average patient actually is 49 years old, has been with us for 8 years. We've seen 8 times. And interestingly, 72% male, which is apparently that figure actually kind of holds up cannabis across the board. This idea of opening up this telemedicine to cannabis is a disaster. It's bad enough out there now. What I can very quickly see will happen is every pot shop in this state will have a little laptop up front. Every 18-year-old, and that includes kids in high school, will step in to, I want to buy a pot. Got your card? No. Go over, stick your $5 or whatever in that box. And no questions asked. Out comes the card for 1 year, and then, the sales are legal, and there you go. And I don't know what could be done about it. It strikes me that the Micarea decision declared that we're the same standard of care regardless. However, the Superior Court ruling at the same time said recommendations are not the same as prescriptions. Perhaps in that discrepancy there's some wiggle room. You guys could go ahead and say in the case of med marijuana, the standard of care actually does require an in-person investigation or an evaluation for the initial at least. Perhaps also they get their lawyers. Y'all got y'all's. As I understand, the AG's office has got over 2,000 attorneys over there. Pot will be legal eventually in probably a couple of years is kind of the general feeling from the underground of this thing at this point in California, who knows. And hopefully can keep a lid on this problem until then. At present, comments were made at the last Med Board meeting that 99% of these recommendations are a joke. And that number may be a little high, but I may well be wrong. It may not be. It's a professional disgrace across the board what has happened to this thing. From the beginning, med marijuana was for the physicians have the role of gatekeeper on med marijuana. But who's the gatekeeper of the physicians? The staff of this institution. And who's the gatekeeper of this staff? And really to the credit of this board, this is the first board that's really stepped up and said, no, something's got to be done about this thing. And I would encourage you guys to pursue that line of thought. Perhaps as you, with all this turnover that's apparently taking place in your senior level enforcement division, this could be a major part of the criteria of who gets those slots again, and perhaps really think twice before you promote someone into it that's been part of the problem getting to where it is now. As MedPot laws crop up all around the nation, you all may not be aware of this in the broader world, there's a recurrent theme in each of these proposals, both anti as well as pro. Florida will be a textbook. Everybody kept saying, we don't want it to wind up like it did in California. In essence, California's been rendered a joke. MedPot's been rendered a joke by the state, and really by the failure of this board to do its fundamental roles of protecting the
Please
the
conclude.
So I just encourage you guys to step up and do more about this thing to clean the mess up rather than just to propagate it. And this teleconference stuff's a disaster. You guys need to figure out a way around it. Thank you and good luck.
Okay, thank you, Dr. Ellis. Any other comments from members in the audience? None? Any comments from anybody on the telephone?
Okay, at this point, we have no one queued up.
No comments? Okay, no comments on the phone. So we have a motion and a second. All in favor? And, well, sorry, going to get used to this. So,
Dr. Lewis?
yes.
Dr. Kraus?
Yes.
Mr. Swanepoel?
Yes.
Ms. Yaroslavsky?
Yes.
And Dr. Yip?
So I don't need opposed and abstentions because I assume we don't have any. Okay, I'm moving on to the same agenda item. The second recommendation of the task force, as we determined was necessary, was an amendment to the Business and Professions Code, Section 2242, to state a recommendation for marijuana must have an appropriate prior examination. Currently, this section of law states in part, I quote, prescribing, dispensing, or furnishing dangerous drugs as defined in section 4022 without an appropriate prior examination and a medical indication constitutes unprofessional conduct, end quote. In the precedential decision we reviewed, we found that when this case went to Superior Court, it stated that a recommendation is not a prescription, and therefore they did not find a violation of Section 2242. The task force recommends a modification to the Section 2242 to require an appropriate examination prior to recommending marijuana. During our review of the new legislation, we found that this amendment is currently in Assembly Bill 26, which we're going to hear also about tomorrow. So our recommendation is to have staff continue to meet with the bill's author's office and to be sure that they are aware of how important this fireworks. I don't know where they're from. How important this amendment is to the law is, and to monitor this bill throughout the process. If the legislation does not move through this year, then the recommendation would be to put this amendment forward as a board-sponsored legislative proposal for year 2016. At this time, we would ask to continue this discussion to tomorrow's legislative agenda item, when the board will be taking a position on Assembly Bill 26.
So what do you want, a motion to table?
So
or
now
what?
can I have a motion to recommend to the full board that Section 2242 be amended either via Assembly Bill 26 or via a board legislation?
Sure, I'll move.
You move?
Second.
We have a second. Are there any comments from members of the audience? No slips. And from the telephone?
We do not at this point.
Okay. Ms. Romero, you're on.
Dr. Lewis,
Yes.
Dr. Kraus,
Yes.
Mr. Serrano Sewell,
Yes.
Ms. Yaroslavsky,
Yes.
Dr. Yip.
Okay. Thank you. Lastly, the task force recommends watching both Assembly Bill 26 and Assembly Bill 34. Now, 34 is just a spot bill at the moment. AB 26 changes the law to require an in-person examination for any recommendation for marijuana. Tomorrow, we will be taking a position on this legislation. If this legislation were to pass, staff would need to amend the board's marijuana statement to comply with the new statutory requirements. Therefore, at this time, we are recommending waiting until this legislative year is completed before any other changes are made. So no motion is needed for that. We're just making a recommendation. We'll discuss it probably tomorrow, that agenda section. Now, are there any additional questions from members of the board? Or Dr. Kraus?
While it is not the Enforcement Committee that determines board policy, and that will be discussed tomorrow, I would hope that we're not creating a misperception regarding our concern about telehealth, and that, not speaking for the Enforcement Committee, but speaking for myself, I have concerns about telehealth being utilized for this purpose, and look forward to the board establishing policy on that matter.
Okay. Thank you. Any other comments from board members? Any comments from anybody in the audience? I don't have any slips. Anybody like to make a comment? And the telephone?
At this point, no.
Okay, now we're moving on to agenda item number 6, which is disciplinary action demographics. Ms. Kirschmeyer, please. Oh, and Ms. Simones, you're part of it. You're just giving her support. Okay, fine. You're allowed.
Well, good afternoon. I wanted to let you know at the last meeting, actually a couple meetings ago, we had the issue of disciplinary demographics come forward to the board. Based upon that, the board asked us to go back and look at our statistics, and at the last meeting, as you all know, in October, we provided the statistics that were gathered from staff's hard work. Based on the comments that were received at the last meeting, once those statistics were presented, the members really directed staff to go back and research a potential third-party organization that could analyze the data that was provided. We went back, and actually I'm going to have Ms. Simoes talk a little bit about what we've done, but we actually reached out to one of the organizations that was mentioned at that meeting, and that was the Office of Health Equity. They're actually an entity that's under the Department of Public Health. And after Ms. Simoes talked to them and they told her what their role was, we've decided to actually move in a different direction. I'll just let her talk about what their role is.
So as Ms. Kirkmeyer said, I did contact the California Department of Public Health's Office of Health Equity. And while they do a lot of things at looking at public health issues from a community perspective, and out in the community, basically once they look at these issues, they come up with recommendations for the director of the Department of Public Health where policy changes could be made. When I kind of explained to them what we're looking at doing, it was mentioned that this isn't really a review that they would do from another state agency, and they don't really have the staff to do a statistical kind of review. It's something that they're very interested in collaborating with us on, but it doesn't really fall in line with the mission of Office of Health Equity. So that's the information I received from the Office of Health Equity.
So once we received that information, Ms. Simoes and I talked about other entities that have done studies for states, organizations, and agencies, and we have done work before with the California Research Bureau. They were actually required by law to come in and do a study, and so we reached out to them, and here with us today is Brian Sala and Patrick Rogers from the California Research Bureau, and we've just asked Brian to come and give you a very short update on basically what the California Research Bureau does, and then what we are going to be asking of the board is that the board authorize staff to do a memorandum of understanding with the California Research Bureau to be the third-party entity to come to the board, gather all of the data that the board has regarding this issue, basically interview the individuals who have come forward on this entity. Both we would like to actually ask the committee and then the full board tomorrow to actually authorize Dr. Kraus to be the individual who looks at the methodology behind it and behind the study, working with the California Research Bureau, just to be that second eyes from the board's perspective. And then we'd also like to ask that the California Research Bureau then go back, gather information from all parties, and then put together a study. And so I'd like Mr. Sala to go ahead and give us a little bit of background from CRB.
Thank you, Ms. Kirkmeyer. Again, my name is Brian Sala. I'm the acting director of the California Research Bureau, which is a division of the California State Library. The CRB was created in 1991 to provide independent, nonpartisan policy research and reference services to the legislature, the governor's office, and other executive branch entities. We are a central services agency. Our funding comes through the general fund and through the Central Services Cost Recovery Fund. Consequently, we typically do not charge for our services, which may be an issue. Certainly, most of the time when I have conversations with potential clients, they're very excited about that component. We have considerable experience with and expertise in conducting complex policy analyses. That's what we do. As you're aware, in 2007, 2008, the Bureau, at the request of the legislature, or direction of the legislature, conducted an analysis of the medical board's enforcement activities and disclosure policies. And the core of that work was somewhat complex econometric exercise examining the determinants, the co-determinants of enforcement activities at the board. That project required the board to provide CRB with full access to its confidential licensing and disciplinary data as a matter of law. As Ms. Kirkmeyer noted, if we were to take on this project, We would need full access to the confidential data, both the survey data and the licensing and disciplinary data, in order to develop a clear understanding of the statistical properties of that data as related to the questions of interest. And that would require an MOU or an IA between the board and the state library, the CRB through the state library. We do not have an exemption under the Public Records Act, so it would be necessary that we expressly address those issues of confidentiality in any such MOU. I should emphasize that CRB's services are provided under the understanding that CRB retains full editorial control and independence in our work. We work for our clients, but our conclusions are our own. And I think in this case in particular, that's a matter of relevance to you as well, that you want it to be very clear that it is CRB's analysis that's being provided to the board. We take direction from the client on the nature of the product that you want us to produce, but we retain full control over the actual analysis and delivery of that product. I'm happy to answer any questions you may have.
And I just wanted to let you know, I have talked to the governor's office on this as well and have mentioned the California Research Bureau, and they were supportive of that in the conversation that we had as well, and in the path that the board was going to be seeking from you.
I think it's a really good thing. I think we have an independent body taking a look, an independent body that has respect statewide, if not further, and there shouldn't be any question as to any issues. I think if any information needs to be redacted, I'm sure it can be redacted by staff, but I would look forward to full cooperation.
I have a question. When you have discussions with anybody, a third party performing statistical analysis or collecting data for you, the question is who owns the data and who has access to it, and what can we as the board do with that data? Do we have to go through you, or?
So in the prior project we worked on relating to board data, the statute specified that CRB would have full access to the confidential data, and we would apply the same confidentiality restrictions on the data as would adhere to the board's requirements. So we put in place all the necessary protections of the confidentiality of that data. The only data that is presented publicly is in aggregate form, making sure that the potential for revelation of identifiable information about any individual licensee is treated very carefully.
It would be our data that they would actually be capturing. So it would be our complaint, investigative, and disciplinary data. And
yeah, I guess maybe I misspoke. It's your data. We would be analyzing your data and then returning your data to you.
That's the question, returning the data back to us. We would be the repository of the data.
And that certainly could be an explicit part of the MOU or IA, that we return all of the data to you at the conclusion of the project. Again, we work for our clients, and we're certainly amenable to conditions such as these where there are practical concerns about the ultimate ownership of the data. We have no need to retain that data for other projects.
Okay, thank you very much. Any other comments? Dr. Kraus?
I think this is a great solution. I look forward to it. I think it's important to also look ahead as to the distribution of the report. I would expect it to be public, but I would, on the other hand, expect for it to be reported first and only to the medical board, and to allow the medical board to be the releasing organization of the analysis, so it's not viewed by the public as something that the medical board may not have solicited. I don't want the release of the analysis to be viewed as by the public as the medical board being under suspicion. So if the analysis comes to us and will be released by us, that would give me greater comfort.
Again, this is a matter for specification in an MOU. We have a range of product responses for clients, ranging from publicly released reports, published reports, which we publish, to quasi-confidential memoranda. Again, we don't have an exemption on the Public Records Act, so completed work product is completed work product, and it becomes exposable. But we would be more than happy to work with the board to specify the format they would prefer for public release, whether that is the board publishes the report, we provide a report to the board, and the board then puts that in an appropriate container, or if you prefer for the CRB to publish the report. That's completely up to you as a client.
Yeah, my point is I fully expect prospectively that regardless of the conclusions, that it is public domain. But I would hope that the MOU states explicitly that the releaser of the information should be the medical board.
I'm perfectly open to that. The key point that I want to make regarding our work is that we have an expectation of retaining full editorial control over content, and that's the assurance that we want to give to your interested parties, that you're receiving our unbiased best analysis.
Yeah, and I think it should be that way. I wouldn't want the public to think that we had manipulated it or fingerprinted it.
Yeah. Mr. Rasul,
Thank you, Dr. Lewis. If it pleases the committee and the board, I would say if you could allow me as the president and the vice president to work with our executive director. We've heard your comments. They're very good, and working in conjunction with the parties and releasing the report in a way that is open and transparent, but provides the reviewer and the reviewee the opportunity to have a report that's beneficial and serves its purpose. So that would be my recommendation.
Okay.
It doesn't need to be a motion.
No, okay. Any comments from other members? Any comments from members of the audience? I have one. Do you have something?
Well, we do need a motion to take it to the full board for approval. So it would basically be a motion to approve, to direct staff to work on an MOU with CRB, in addition with Dr. Kraus looking at the methodology behind the statistics and working with Mr. Serrano-Sewell on the write-up of the Memorandum of Understanding and IA.
So moved.
Second?
Second.
Okay. Any questions or comments from members of the audience? I have one from Yvonne Chung, CMA.
Good afternoon, Yvonne Chung with the California Medical Board. I'm sorry, California Medical Association. I just gave myself a promotion. I wanted to.
You're here so much.
I wanted to let you know that the California Medical Association is supportive of the recommendation to have CRB perform this analysis. We think it's appropriate. We are supporters of ethnic diversity within the physician population, and this is a good way for the board to begin to take steps to identify if a problem does exist and to start to craft solutions to address that problem so that we can maintain diversity in our physician population. Thank you.
Thank you, Ms. John. Any other comments from members of the audience?
Good afternoon. Julie D'Angelo Felmuth from the Center for Public Interest Law. I also served as the Medical Board Enforcement Monitor between 2003 and 2005. As one of the many issues that we studied, we looked at your public disclosure policy. We made a number of recommendations in that regard. The legislature, though, decided to have another third-party outside external reviewer look at that public disclosure policy and our recommendations. And the CRB, and specifically Dr. Sala, eventually took on that study, as has been mentioned to you. They put out an excellent report in 2008, and that report, importantly, was the subject of successful legislation last year, AB 1886 Eggman, which has now improved your public disclosure policy to the benefit of patients and to the benefit of your staff. It saves your staff a lot of time and money, because your most important enforcement decisions, which are public information, are now posted on your website indefinitely and not just for 10 years. So Dr. Sala and CRB has had an important contribution to this board already, and I envision them as having another important contribution in this area of physician diversity. Thank you.
Thank you for your comments. Any other comments from members of the audience? Comments from anybody on the telephone?
Okay, if you do have a comment from the phone, star and 1, and I'll open your line. We have no questions in queue.
No comment? Okay. So, Ms. Romero, you're on.
Dr. Lewis?
Yes.
Dr. Kraus?
Yes.
Mr. Serrano Sul?
Yes.
Ms. Yaroslavsky?
Yes?
Dr. Yip?
Passes. Okay. Now on to the second to the last agenda item. Future agenda items. So do any members of the board have any future agenda items for the Enforcement Committee? Dr. Kraus, please.
Although we spend time today discussing marijuana, I think that we also need to have similar discussions of scheduled drugs. That could either be a subject for the full board, but I think the Enforcement Committee needs to look at that as well as it relates to telehealth.
Could you just expand on that just a little bit so I can understand?
Just as I have previously expressed reservations about individuals using telehealth as a first examination for recommendations for marijuana, I have similar concerns about telehealth potentially being an avenue for first prescription for scheduled drugs. And while I'm happy to bring that to the full board, I think it's also a subject for the Enforcement Committee to look at.
Okay, thank you for that. So we'll talk with staff about seeing how the best to proceed with that on probably the Enforcement Committee for the next meeting. Thank you. Any other future agenda items anybody would like to bring up? Anybody in the audience? Any comments from members of the audience on future agenda items for the Enforcement Committee?
So let me ask a question. Will enforcement committees continue to have presentation by the DCA?
DCA and the DOJ.
Okay, so then I don't need to do that. Thank
No,
you.
I think at one of the meetings before, we mentioned that we would have updates at every board meeting.
Perfect,
I think
thank
I
you.
brought that up.
My
So
apologies.
I think that'll be a standing
Thank you.
presentation. Okay. Anybody on the phone?
We do not.
Okay. The last agenda item is adjournment. Do I have a motion to adjourn?
So moved.
Second? Meeting adjourned. Thank you very much.